Hello, my name is Noor, and with my friend Clara, we will explain model of administrative justice in Australia. I will explain the three stages, the initial decision recognition and judicial review, and Clara will explain the key variables, the separated tribunal, the adversarial hearing procedure, the closed review, and the generalized court. So first of all, the three stages. We have the initial decision. This is a process of reviewing or appealing the decision of a federal administrative agency, usually begins within the agency itself. And before a party might be able to challenge the decision in an actual court, they typically must file an appeal within the administrative agency that issued the decision. So in Australia, the Administrative Appeals Tribunal conducts independent merits review of administrative decisions made under Commonwealth laws. They review decisions made by Australian government ministries, departments, and agencies. The agencies can only review a decision if a law states that the decision can be reviewed by the AAT. This means that they take a fresh look at the relevant facts, the law, and the policies and arrive at their own decision, taking the legally correct decision. So the AAT was established by the Administrative Appeals Tribunal Act in 1975, and this act requires legislation to have sufficient regard to the rights and liberties of individuals subject to administrative powers and identifies the issue of whether the power is subject to appropriate review as being relevant to whether this requirement is satisfied and whether a particular decision that affects the rights of an individual should be reviewable or not depends on a range of circumstances. So secondly, we have the reconsideration of the initial decisions. This is a reconsideration if the applicant of the initial decision is not satisfied with it and the review, and only applies if the agency decides to provide a right of review for a decision. The issue this is to determine whether the new right of review should be dealt with an external merit review body or an internal review body. Although the policies require internal review to be considered in all the cases, there will be occasions when it is not appropriate for a decision to be subject to internal review, even as a first step in the process, and it should be referred directly to the external review. In the cases where it is appropriate, the initial review process it is to be conducted within the government agency that made the original decision. That decision lends itself to a simple, informal, and quick internal review mechanism. The external review, the significant feature of the external merit review is that it is independent of the original decision maker. As the review occurs outside of the influence of the original decision maker, the members of the merit review bodies also have specialist skills at reviewing decisions that are complex, but the difference that they have with the internal review body is that the expertise and the extent of the powers of the internal decision makers are sometimes more limited by way of for legislation or rules. So in conclusion, the second review can be external or internal, but if it ends to be firstly internal and external, there will be two reconsiderations. And finally, we have the judicial review, which it is widely recognized that the right to judicial review is not absolute, but it is available to test the legality of a decision, but not the merits. The courts are not authorized to ask whether a decision was a good decision. It asks only whether the decision has been properly made in accordance with the law. So decisions about whether judicial review under the Judicial Review Act of 1991 should apply. The judicial and merit review process are completely different, and the merit review involves standing in the shoes of the original decision maker, as I said, reconsidering the facts, the law, the policies, aspects of the original decision, and the judicial review has a narrower focus and relates primarily to the legality of how the decision was made. The court has jurisdiction under the Judiciary Act to hear applications for judicial review of decision by officers of the Commonwealth. Many of the cases also arise under the Administrative Decision Act of 1977, which provides for judicial review of most administrative decisions made under Commonwealth enactments on grounds relating to the legality rather than the merits. The court also hears appeals on questions of law from the Administrative Appeals Tribunal. The administrative decisions as part of wide-ranging reforms to federal administrative law in Australia seeks to simplify, codify, and in some cases expand common law judicial review. It also established a single simple procedure for review which applies regardless of the grounds argued or the remedy sought.
Now, regarding the key variables in Australia, first of all, there is a separated tribunal. The reconsideration decision is made by a tribunal that is separate from the investigating and the prosecuting agency. Australia invests most of their adjudicatory resources in the reconsideration process, which is provided by the tribunals. That is the level that the private parties regard as providing the best chance to win a favorable outcome. At the initial agency decision level, there are few procedural requirements, but at the judicial review level, the narrow scope of the review precludes the courts from affording relief in most cases which involves disputes of fact or discretion. These initial decisions are reconsidered by tribunals. A request for reconsideration under DRCA, Section 62, must be made in writing and must be lodged by a DVA no later than 30 days after you received advice of the decision you wish to have reconsidered. Traditionally, Australia provided a separated tribunal for each agency. However, in 1976, it merged them into a single body, which is known as the Administrative Appeals Tribunal, which is the AAT. The AAT is an independent review body with the power to conduct merits review of administrative decisions made under the Commonwealth laws, including all the decisions of the VRB, as well as the decisions made by the delegates under the DRCA and MRCA. The AAT provides trial-type recognition hearings for over 400 agencies. In some cases, also including Social Security, Veterans Benefits, and Migrations, there are specialized tribunals, which in the AAT then provides a second level of reconsideration from some decisions of these specialized tribunals. The AAT decisions can be appealed for the federal court, but only on a question of law. Therefore, if your interests are affected by the Secretary's decision following the reconsideration of the initial decision, then you may apply to the AAT for a review of the Secretary's decisions. This review can only take place after the Secretary has reconsidered the initial decision. Moving on to the adversary hearing that it takes place in Australia, it relies on a two-sided structure of the opponent sides, which each presents their own position with an impartial judge or jury, hearing each side and determining the truth in each case. In the adversarial system, each party presents the arguments, makes submissions, and provides evidence to support their versions of the events. Each party controls the preparation and presentation of the case. In a criminal trial, a jury or a magistrate or a judge, in some circumstances, will decide whether it has been proved that the case has gone beyond a reasonable doubt. And in a civil case, a judicial officer or a jury, in some circumstances, will decide whether the party that started the proceedings has proved their version of the events to the standard of their proof required. The decision of a judicial officer or jury is confined to the issues in a dispute, and the court does not own its own investigation. The initial decision occurs after the adversarial hearing presided over by a hearing officer. The hearing officer works for the agency in question, but did not participate in the investigation, neither in the prosecution of the case which the officer decides. The rules of the evidence and the procedure are strict, and in the adversary system or trial, the aim is to ensure that the trial is fair and unbiased, and that the parties have an equal opportunity in order to present their case. So some rules of the evidence are that only certain types of evidence are admissible and others are admissible. Only relevant and reliable evidence is allowed. This can come in the form of oral, documentary, or even an expert evidence. Inadmissible evidence includes evidence that is obtained in an unlawful manner. These rules ensure that the parties are treated in a fair way. Some rules of the procedure also include that a hearing is to be single and also continuous. Also, questioning these stages are also organized strictly, and the delays will occur but are also ideally minimized. Furthermore, the judge's main roles during the case are in order to control the proceedings and to ensure that these rules of evidence and procedure are followed strictly. This means that a judge decides what evidence is admissible and also decides the relevant law that is to be applied. The court can only make decisions on the issues that the parties indicate to the court in the disputes and decides only on the basis of the evidence arguments which are presented to the court by the parties. The court does not conduct its own investigation, neither constructs its own versions of the event. Regarding the closed review, the courts of general jurisdiction provide a judicial review of the legality and also the reasonable of the agency decision. Judicial review is closed, which means no new evidence, no new arguments, neither reasons. And the court does not substitute its judgment for that of the agency concerning matters of law, fact, neither discretion. The traditional Australian system of the adjudication follows the British model. At the initial decision level, Australian agencies generally provide an opportunity for the review by an official who was not involved in the investigation of the matter. That review process often furnishes an opportunity for the private party to make a written submission, as mentioned before, and sometimes for a meeting or even a phone call between both private parties and the reviewer. Regarding the generalist courts in Australia, the judicial review is closed and it takes place in generalized courts. As mentioned before, the courts of general jurisdiction provide a judicial review of the legality and also the reasonable of the agency decision. And these four principal federal courts can be divided into the High Court of Australia, the Federal Court of Australia, Family Court of Australia, Federal Circuit of Australia, and the High Court of Australia sits at the apex of the Australian court of hierarchy, as is the ultimate court of appeal on matters of both federal and also state law. Decisions of the High Court are binding on all the Australian courts, including the state and territory Supreme Courts. The High Court has limited trial powers, but very rarely exercises them. It has an ample power in order to transfer cases which started and which finds more appropriate court, so that the High Court can conserve its energies for the appellate functions, which is their aim. The large number of courts in Australia have also different procedural powers and characteristics. but they also have different jurisdiction limits and different remedial powers, as well as different cost structures. Therefore, each state in Australian territory has a court hierarchy of its own, with the jurisdictions of each court varying from state to state and territory to territory. However, it's important to state that all the states and territories have a Supreme Court, which is a superior court of record and is the highest court within that state or territory. Decisions of the high courts are binding on all the Australian courts, which include the state Supreme Courts. Under the Australian Constitution, the federal judicial power is vested in the High Court and such federal courts as may be created by the federal parliament. Lastly, common law and equity are administered by the same courts, and the legal and equitable remedies may be pursued in the one action in the one court in question. Thank you very much for watching.